This Honorable Court of Appeals of Tennessee is now in session.
All right. Thank you, Mr. Hibner. Before we call the case, I want to run over the ground rules very quickly and also introduce our panel. Today's panel is Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Both of you have been to the Court of Appeals before, I'm sure, so you know the procedure. Essentially, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your argument. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. I want to thank Mr. Hibner for being the quarterback of all this and putting it all together. He's done a masterful job as we've tried to continue to move these cases during this pandemic. Working very closely with him has been the AOC technology staff, who have also done a wonderful job. So without any further ado, Mr. Hibner, if you will call the case, please.
Fatma, Adel, Sekik versus Nehad, Abdelnabi et al.
Okay, we will hear from the appellant. I think you're muted.
Thank you.
Yes, sir.
Is Ms. Sobieski in the room? I don't see her on the screen.
She's on the screen.
Okay, she's on the screen. May it please the court. My name is Matt Barocas. I'm an attorney in Knoxville, and I'm the attorney for the appellants Nehad, Abdelnabi, and Riwa Garbawi. I would like to reserve 2 minutes for rebuttal, if I may, please.
Certainly may. You may proceed.
Thank you, Your Honor. This is a divorce case that was filed in 2012 following a 15-year marriage, 4 children, and the arrest and conviction of the husband for aggravated assault and kidnapping. The spousal parties were married in Egypt in 1996. The spousal parties continued to live together after the husband's arrest in 2012 until he was convicted, sentenced, and incarcerated in 2016. Now, I represent the brother and sister-in-law of the husband in this divorce case. So the brother and sister-in-law were added as additional defendants in this divorce case. Now, while incarcerated, the husband, desperate to save his commercial building in Knoxville for the benefit of his only son, capable of working, so that his son could work to support his other son with special needs, enlisted the efforts of his brother, my client, Nehad Abdelnabi, so they share a very similar name, who was in the Gaza Strip, to sell land in the Gaza Strip and send money to pay off a commercial mortgage against the commercial property in Knoxville.
So you do, excuse me just a second, you do not represent the husband, is that correct?
That is correct, Your Honor. I represent the brother and the sister-in-law of the husband in this divorce case. And so my client acted—
Let me ask you one more procedural question before we get in too deep. The trial court granted a default judgment against the sister-in-law. I did not see that raised as an issue on appeal.
Well, I was not the attorney who answered this lawsuit. Personal jurisdiction was not contested by them. I would suggest that it didn't appear as though service of process was proper here, but no, I didn't raise it in my appeal. There's so many issues in this case, procedurally and evidentiary issues, and I did not raise that issue, but I think it's an issue in the future. I could try to weave that into my argument. In the event that this lower court judgment is upheld, I think we'll have all kinds of issues with folks being joined in divorce cases and maybe demanding a jury trial where they, where a husband and wife may not have a right to a jury trial. You'll have folks demanding jury trials for these supplementary claims if in fact this becomes the law of the state of Tennessee. But my client, while in the Gaza Strip, raised $451,000 and paid off the mortgage on the Gleason Road property in the amount of $187,000. And during the pendency of this case, my client made mortgage payments on that same property on Gleason Road, totaling, I believe, $16,000 or $18,000 in addition to that $187,000 mortgage payment. So he saved this property on the Gleason Road for the benefit of the spousal parties.
Let me ask you a question, counsel. All these things that you're saying, are they in the record?
Yes, sir. All
Okay.
these preserved,
There was testimony to this effect. Is that correct?
and all that is in the record with the court.
Okay.
Court. So the Gleason Road property, which would have fallen in foreclosure had my client not made those monthly payments towards it and paid it off ultimately, was awarded to the wife in this divorce, awarded to her free and clear, and valued at $239,000. Had it not been for the actions taken by my client, I know that the appellee is suggesting that it was done in contravention of the trial court's orders, but I don't believe that you can be held to have violated a court order in which you are not a spousal party. You are not a defendant in the lawsuit. You don't receive actual notice of that court order. Now, the biggest issue and the first issue that we're arguing is that the trial court lacks subject matter jurisdiction in this case. So what is the gravamen of the complaint, the cause of action, the relief sought? If we review the wherefore clause, the prayer for relief in the amended complaint, all right, it seeks that all transfers of property, okay, be from Nehad and or Nehad and his wife be declared null and void, and the property be disgorged and restored to the marital estate, or that judgment enter against all the defendants jointly and severally for all funds received that relate to the property and losses associated with their actions or inaction. What is subject matter jurisdiction? It's the power of a court to hear a case, okay, based on the authority granted to the court to hear that type of case. So we need to, I think, look at what is the Gaza Strip. The Gaza Strip is a tract of land in the Eastern Mediterranean controlled by Hamas, which is an internationally recognized terrorist organization. And I put a case in there. The only case I could find that references the Gaza Strip is a Ninth Circuit Court of Appeals case. Now, it's been designated by the Secretary of State, okay, in accordance with the Section 219 of the Immigration of Nationality Act, as a foreign terrorist organization. That's since October 8th of 1997. And my position, my client's position, the divorce court in Knoxville did not have the power to nullify any property transfer in the Gaza Strip, and it should have dismissed the amended complaint for lack of subject matter jurisdiction. I raised those issues. We could raise them now, but we've raised them in our brief. Now, I wanted to go through the case. I didn't file a reply brief here. I wanted to go through the cases cited by the appellee. Okay, I don't think that they're on point. I think they're all distinguishable. The appellee cites Easton for the principle that so long as the divorce court has personal jurisdiction, it may compel parties to take action with respect to property located outside the physical boundaries of the court's jurisdiction. But I believe that that argument fails for two reasons. The property at issue is located in the Gaza Strip, this territory controlled by a terrorist organization. Okay, and here the divorce court compelled non-spousal parties to take action with respect to property in the Gaza Strip. So I believe those are critical material distinctions. The appellee cites Watkins and Watkins, again, ignoring the material facts that my clients are not spousal parties and Gaza is not a country. Okay, appellee.
Excuse me, sir. Were your clients made parties to the lawsuit?
They were eventually made parties to the lawsuit.
Were they parties to the lawsuit when the actions that you're describing occurred?
No, my client was served with the lawsuit after, well, there were several transactions. He was made a party to the lawsuit August 25th of 2017. And the transactions that occurred, some preceded them and some followed.
Did the court order your clients to do anything or enter any orders against your clients requiring them to do anything prior to the time that they were made parties to the lawsuit?
Prior time, no. It was in the final order that the trial court ordered them to go to the Gaza Strip and to take action concerning the property.
So assuming the court had jurisdiction over your clients, any action the court took occurred after the court acquired jurisdiction over your clients. Is that correct? Assuming the court had jurisdiction.
Well,
No action was taken no action was taken by the court against your clients until the court had jurisdiction, assuming it did. Is that right? That's a yes or no answer.
Yes, Your Honor. Well, everything was ordered in the
That's a yes or no answer, sir.
Yes, sir. Well, yeah, and the final order was after anything that happened, and so they ordered them to take action in the future.
Your client was served. Your client filed an answer. You represented them. No action was taken before all of that occurred. Is that right?
I want to make sure I understand the question. No action was taken by whom?
No action was taken by the court against your clients, ordering them to do anything until they were served the process. They hired you, presumably. You responded to that. You had hearings, and ultimately an order was entered. Is that right?
Well, they asserted they assumed personal jurisdiction over my clients, and then ordered them to take a series of actions with respect to property located in the Gaza Strip after the order was entered.
Where were your clients living at the time that they were served with process?
Lawrenceville, Georgia.
All right, go ahead.
The appellee relies on the conspiracy theory of personal jurisdiction articulated in Chenault. And if the appellee is correct that it's proper for a divorce court to exercise personal jurisdiction over out-of-state co-conspirators who interfere with the marital estate, I believe is a matter of that would not be sound policy. Spousal parties will start including their family and friends as additional parties in divorce cases, suggesting that they've somehow interfered with the marital estate. My client acted pursuant to power bestowed upon him by his brother and didn't act in contravention of that power of attorney. And again, concerning this land in the Gaza Strip, the Emerson case is not on point.
Let me ask you a question. Are you saying that your clients were unaware that they could not take these actions?
My client's position is that
No. Well, listen closely to my question. Are you saying that your clients were not aware that they could not take the actions that they took, that the trial court found that they should not have taken?
My clients were Nehad Abdelnabi. Any of the actions that he took he acted for his brother. His brother begged him from prison to take.
I understand that point, but what the question is, were your clients advised, or did they know that since he couldn't take these actions, they couldn't take the actions for him?
I don't believe.
Lost it.
He's frozen. Mr. Hibner?
Your Honor, let me, well, I guess we'll have to pause for right now.
Yeah,
See what's
let's
going on.
pause for a moment and see what we can do.
Mr. Brokus is trying to log back in with us, so.
Okay. go.
Thank you, and I apologize.
That's not a problem. Not a problem. You were answering the question about whether your clients were aware that they could not take the actions that they took.
Oh, I don't think that they were. I don't.
Excuse me, can we give him 2 minutes? Can we give him 2 minutes? I think we may have lost some time there.
Yeah, we'll give him, go ahead.
Thank you. I was going through the cases cited by the appellee in support for their position joining the brother and sister-in-law as additional defendants in the divorce case. The Emerson case involved an injury in the marital context. It was not a divorce case per se. The Brown case cited by the appellee was not a divorce case either. It involved former spouses. It concerned child support. The Smith case, the court reasoned it was proper to include the mother-in-law of the wife on the basis that she had claimed an interest in the equity realized from the sale of a marital home, and joinder was appropriate in that case pursuant to Rule 19.01. The wife's divorce suit was filed prior to the mother-in-law's claim, and then joinder was necessary because the mother-in-law claimed an interest in the subject of that action, and adjudication could not have been made without joining the mother-in-law. The Toms case, the court addressed the question of whether or not grandparents can intervene in a divorce case. This is different than the case that we have here. The court assigned a value of $1.3 million to this property in the Gaza Strip. Nobody was competent to testify as to the value of the property located in the Gaza Strip. We didn't hear from a single expert. It was all the spousal parties, the children of the marriage, a couple of folks relating to the children and their education and things of that nature. There was nobody competent to testify as to it. The court relied on the method evaluation submitted by the plaintiff without any further description, and I think that is insufficient under the laws of the state. This notion of civil conspiracy, we've argued that there's no predicate tort to support a claim. Dissipation of marital assets, we don't believe is a tort. Violation of the court orders, we've argued that they didn't have notice of any of the court orders. And that's my time until rebuttal.
All right, thank you. We'll hear from the appellee.
Hello, I'm Wanda Sobieski, and I represent Fatma Sekik in this matter. We joined the brother and sister-in-law on a theory of conspiracy jurisdiction because they knowingly interfered with the marital property in the estate. We had had a hearing in January of 2017 before Judge McMillan, at which time we explained what was happening. There were some attempts to sell some of the property, and the most valuable property was that was located in the Gaza Strip. Husband initially denied that such property existed, even filed a pleading with the court claiming it to be fictional property, but ultimately admitted it did exist and was worth about $2 million in his own testimony as the owner of the property. When the court held the hearing in January, the court set up a system because husband was in jail and prison, set up a system for the wife to maintain the properties, to collect the rents that were being rented from the chalet in Gaza Strip and from the orchard in Gaza Strip, and to basically account for it to the court to maintain the condos and so forth, pending the final hearing of divorce. Shortly thereafter, husband and his brother and sister-in-law entered into a conspiracy to dispose of property in the Gaza Strip and to place the cash from that disposal beyond the reach of my client. When we were able to have enough evidence to pursue it, we then, of course, joined the husband and his sister-in-law in the lawsuit. They obtained a person who was supposed to be a notary public from Florida to go and draft and execute a power of attorney, have the imprisoned husband execute a power of attorney to the brother. And so the brother could then, while he was in Gaza Strip on other business, sell a portion of the marital property. And he did so. He sold one portion of it for $451,000. And that was just a small piece. The property consists of 3 strips, one that has a chalet built on it with a swimming pool that's a vacation home. And then the other is, part of it is an orchard that is developed with figs and various plants. And then there's a small strip adjoining that. And that's what he sold, the unimproved portion of the property for $451,000. And while some of that money was applied to the shop on Gleason, and we've all never disputed that, and that benefited the marital estate, the rest of it disappeared. And in the meantime, all this time, the wife has gotten no support. There's been no child support paid for years and years. I mean, they've been in very dire circumstances. So the question is, I guess, is whether Chenault versus Walker, which is the Tennessee Supreme Court's latest decision in 2001 on the joinder for conspiracy, still holds. And I don't think there's been anything to suggest that the Supreme Court or any court in Tennessee has altered that notion that if a person outside the jurisdictional limits of the state conspires with someone in the state to injure someone in the state, then the court may assume jurisdiction, and the court did so. That was the personal jurisdiction. Now, there was never, as Appley claims, an assertion of in rem jurisdiction. What the court has asserted is personal jurisdiction over the husband and wife that coordinated together with, the husband and the brother and sister-in-law that all coordinated together to try to place this property outside the marital estate. And so the court took personal jurisdiction by the conspiracy because of the conspiracy. And Your Honor asked an important question, and that was, did these people know they were conducting an activity that was illegal? And I think the record is perfectly clear that they absolutely did know. The brother and sister-in-law had previously filed a divorce and actually been through a divorce in the state of Georgia. And the proof showed that during that time, the brother took certain monies and jewelry and gave it to the husband for safekeeping, quote unquote, during that divorce. He was served with an injunction much similar to ours when we started a divorce case in Tennessee. And ultimately, he had to retrieve those goods from the husband and make them available to the marital estate. Both brother-in-law and sister testified that they knew that it was illegal in this country to interfere with marital property during the pendency of a divorce. And so they knowingly entered into a fraudulent scheme to defraud the trial court and, of course, my client, Fatma Sekik. That supports this conspiracy jurisdiction, and also gives the court the authority to order recompense however the court can best do it. Now, we are complicated. The case is complicated by the fact that some of this property and the most valuable property is located in the Gaza Strip. We know brother knows how to sell property there and has the contact to do so. He not only sold that portion for $451,000, he transferred a portion of that property to himself that was worth another $250,000. And he also purchased other property in Gaza Strip when he was there during that extended stay. So the court has ordered him to sell the property, or ordered them to sell the property. And that's the only way we can get it liquidated to take care of child support, alimony, and other things that are so importantly needed. Now, as to the value of the Gaza Strip, the husband testified that the property as a whole, before the sale of the portion of it by the brother, was worth of $2 million, at least $2 million. My client, using information that she had and the sale price brother got for that portion of unimproved property, estimated the value at $1.3 million. So it's considerably less, and that's the value the trial court decided to adopt, chose the lower of the two. We did have an issue over whether a spouse who's not listed on the title, but nonetheless by law has an equitable interest in the property, could testify as to value. And I cited on our response brief the only cases I found that were actually in the context of criminal law, where the sentencing guidelines took into account the value of property that was damaged. And I cited both State versus Holt and State versus Mills, where the court held that a spouse whose name was not on the title, but who was nonetheless the spouse, could testify. And in fact, in those cases did testify and actually wind up enhancing the sentence for that time. So basically, what the trial court did here is what the trial court would do, I think, at any time that you have one party attempting to sell off marital property before the trial during the pendency of a divorce. It was certainly within the trial court's ability to bring those parties in under conspiracy theory jurisdiction. Arguably, they are indispensable parties under Rule 19 because they were holding some of the property in their name at the time of trial. The brother was holding some property in his name that he transferred to himself. So to give complete relief among the parties, the court needed to have before him the parties that actually caused the damage to the marital estate. I think there was one other issue raised suggesting that there was punitive damages. Punitive damages, in the brief at least, punitive damages were not requested and no punitive damages were awarded. So I don't think that particular issue is of particular import. The trial court did not exceed the request for relief because Ms. Sekik sought that the judgment, joint and severally, against the conspirators for any of the losses she and the children sustained as a result of their illegal activity in interacting with this property. And that is exactly what the court granted. And so unless the court has some question about any specific part of the record or the argument.
I don't see any, so thank you.
Thank you.
We'll hear from the appellant in rebuttal now.
Thank you. The theory of the civil conspiracy theory is a theory of personal jurisdiction. And of course, the court must also have subject matter jurisdiction, which we've challenged that they did not. The appellee conveniently suggests that the husband's valuation of the so-called Gaza property at $2 million is credible, yet he's incredible and unbelievable with regard to anything else. I believe that this husband was trying to stir up this feeling that he's accumulated this massive fortune that because now he's incarcerated, the family will never realize. And so I don't think he's credible with regard to any of his testimony there. Obviously, he knowingly and intentionally violated all kinds of court orders. This argument that my client put cash from the disposal beyond the reach of the plaintiff and her family is not accurate because my client paid off and preserved that marital liability in Gleason Drive that's valued at $230 some odd thousand that the plaintiff was awarded. Okay, and I would reiterate, nobody's competent to testify as to property values in the Gaza Strip. Neither of the attorneys, none of the witnesses that testified, the trial court, absent expert testimony. We do believe that the trial court awarded more than was demanded. They sought a money judgment. What they received was a series of injunctions. We're ordering people to go to war-torn countries that are controlled by terrorists. My client attempted to, anything he did was what the husband had told him to do while he was crying and desperate and pleading with him. And my client, I believe, is also a victim of the husband. The cases that were cited for a non-owner testifying as to property value, certainly those were not $1 million evaluations, and those concern personal property and not real property.
All right, thank you, sir. You used your time.
Thank you.
Council, we will attempt to get you an opinion at the earliest possible time. We appreciate you participating in these video oral arguments. Sorry for the glitch that we incurred, but it's our best effort to keep the wheels of justice turning during this very difficult time. Again, we appreciate Mr. Hibner being the mastermind behind all this and the AOC staff. And we will do our best to get you something in the near future. Mr. Hibner, if you will recess until the call of the next case, please.
The Honorable Court is now in recess until 1:30 p.m.